Hello, everyone. Welcome to our January TTR Presents featuring Pavithri Kilgore with KPSK Consulting, Small Business, Big Compliance, How to Protect Yourself When Hiring. And I'm going to turn it right over to our newest global partner. Not only is she that, but she's also a wealth of information. So we're so happy you could carve out time for us, Pavithri. Thank you for being here and take it away. We're ready. We're ready.
Absolutely, and thank you for the invitation.
You're very welcome.
Like Jennifer said, I'm the owner of KPSK Consulting, which provides fractional HR consulting across the US and US territories. I started KPSK about 4 years ago after spending almost 15 years working in large Fortune 500 companies, mostly defending them against government agency charges and investigations of employee complaints. So let me share a quick story on why it's important that you have someone with experience watching out for your business. Right when I first got started, a friend of mine reached out at the beginning of the pandemic and asked me if I would help him and his friend's company to get through COVID. So they had an HR person. She's new to the subject altogether. So I was working with her throughout COVID, going to the next year, and I was like, hey, it's time to file your OSHA 300. And she looked at me like I had two heads. I was like, do you know what an OSHA 300 is? And she's like, I have no clue what you're talking about. It's like, okay, you have a safety handbook. I'm like, who did your safety handbook? And she goes, well, the payroll company who's kind of been HR consulting till you came along, they did the safety handbook. And I'm like, they never told you you had to file an OSHA 300. She's like, no. I'm like, okay, how long have you had more than 20 employees? She's like, oh, about 10 years. Long story short, it's a $10,000 fine per year and ended up with a $100,000 fine. Yes, I was able to get them out of it. No, I'm not always that lucky. Problem with not using somebody who lives in this day in and day out is your answers are only as good as the questions you know to ask. About 80% of the small businesses that declare bankruptcy do it because they can't afford to pay fines from government agencies or litigation. I'm a strong believer that no one wakes up in the morning with the intention of doing things wrong or against regulation, but simply because no one is giving you the information you need. So I've made it my business to know your business so I can be that trusted partner and advisor to help you. So today I'm going to go through things you need to think about having in place before you hire your first employee, or if you already have employees, things you need to be aware of, and it's never too late to course correct. Government agencies, federal and state, have multitude of regulations you need to follow. We have a lot to cover, and also it's hard for me to monitor. So like we were talking about earlier, interrupt me, ask questions as we go along. That's fine. And I'll also stay up after if anybody needs additional time. We'll also do Q&A later. So this is a quick list of the things we're going to cover. So we'll get going unless anybody has any questions before we go. All right. Okay.
Pavithri, real
Yes.
quick, Pavithri, how much did you say that I'm sorry, I was trying to unmute.
No, you're good.
How much did you say that they were possibly being penalized, but you helped them?
$100,000.
Okay, that's what I thought you said. Okay, sorry, I was trying to unmute. Okay, go ahead.
No, you're good.
Thank you.
Yeah. So, independent contractors versus employees, right? So it's either going to be a 1099 or a W-2. How do you tell the difference? So let's talk about an employee first. They're either going to be paid hourly or by salary. They're going to be using the employer's material, tools, and equipment. Typically works for one employer. There's a continuing working relationship at will are a defined term. You as the employer decides the manner and means of performing the work, and then the employer determines what work is going to be performed. For an independent contractor, most of the time, you're paid upon completion of a project. The independent contractor provides their own material. They work for multiple clients. Sometimes they're very temporary relationships until the project's complete. The contractor decides the manner and means of performing, and the contractor and client agrees to the project scope. Like everything else in HR, some states have much more expansive criteria for who can be classified as 1099. This is a general guideline on vetting in if someone should be an employee or 1099. You need to check your state regulations to see if you need to apply additional criteria before you can classify someone. So in the state of Indiana, there are no specific state regulations around 1099 contractors, but should be following the Department of Labor information as it relates. I'm going to go through both variations in depth during the presentation, so feel free to stop and ask questions as we go through. All right, you're ready to hire. What do you need to do? Before you hire your first employee, you need to make sure that you have the basic information together to protect your business, employees, and your brand, right? So job descriptions, new hire onboarding packets, employee handbooks, compliance posters, federal and state, workers' comp insurance, payroll system, unemployment setup with the state. These are all things as an employer that you are required to have in place. Optional, you can have health insurance, life insurance, long-term, short-term disability, retirement planning, 401k, simple IRA. Those are all optional. You are not required to provide health insurance until you have 50 employees or equivalent of 50 full-time employees by law.
So a quick question on the checklist. That for temporary employees too, do you have to do the exact same thing for temporary employees, or do you have another route you go with them versus a full-time employee?
Temporary, full-time, part-time does not make a difference. The only difference is if they are W-2 internal or 1099.
Okay, thank you.
Yeah, absolutely. Any other questions? Okay. All right, fun stuff. Legal requirements. You need to have an EIN. Register with the IRS, you get the EIN. State ID. In most states, you get this through the Secretary of the State or the state licensing agency. If you are physically going to have a presence in another state and you're operating a business in another state, you need to have registered with all of those states for state unemployment and workers' comp. But if you are solely based out of Indiana and your work is primarily done out of Indiana, but you provide services outside the state, you're only required to be registered in Indiana. Unemployment setup with the state. Anytime you have an intern employee, you need to make sure that you register your EIN with the state unemployment office and report the earnings, and you can do that through the Department of Workforce Development. Payroll system. Okay. There's a lot of payroll systems out there, and I also know that you can do payroll through things like QuickBooks. Make sure you are using a system that takes a lot of the liability out of your hands. Payroll taxes can get really complicated. Filings can get very annoying. If you're using a reputable payroll system, they should be doing all of your quarterly filings and they should be owning all liabilities surrounding all of your filings and your tax payments. So if they mess it up, they should be fixing it, paying your penalties, not you. If you need help with that, let me know. I have some payroll companies I work with. I trust them. If you need help on that, let me know. Workers' comp insurance. It is super important you have this, right? Regardless of the industry. So you can be in construction where it's prone to injuries, or you can have a office where everybody just sits behind a desk. Well, guess what? We're in Indiana. I see sidewalks. One of your employees slips and falls. It's still work property. You're on the hook. You need workers' comp. Believe it or not, there's an uptick in carpal tunnel claims for office workers. It's the things you don't think about that's going to come back and bite you. And then compliance posters. Most payroll services will provide these for you. If not, you can download both the state and federal ones off of the state and federal DOL websites without having to pay for any of it. All right, that was a whole bunch of information I just dumped. Any questions? Good?
Yes, I have a question.
Yes.
So what size business does this become applicable? If there is an owner and say one employee, is all of this
Yes.
applicable?
It starts, so a company's liability changes based on the number of employees, and it starts with 1. And it's 1, 5, 10, 15, 20, 25, 50, 75, 100, 250. So what that means is it doesn't matter if you have 1 employee or 1,000, the law is the same.
Okay. But if you're just a solopreneur without any employees,
You're good for the
you're
moment.
good. Okay.
If you're
Gotcha.
expanding,
Thank you.
you need to think it through.
Yeah.
Marianne, did you have your hand up or did I just see things?
Sorry, yes, I did have a question. For the compliance posters, if it's a particular, like what if we don't have an actual office where workers, like employees come and work, they're going out in the field to work?
Okay.
How does that work? With the compliance posters?
So if you don't have a central location where the employees meet in the mornings or afternoons, anything like that, and especially right now with the whole remote working, you are still required to provide it to them electronically. So whether you have a meeting and hand the physical papers to them, I would still recommend you do it electronically so you have records of having provided it to them.
Makes sense. Thank you.
Yeah. Because at the end of the day, the big thing is making sure that you have records of everything you're doing so that in the event of an audit, you can produce it. Any other questions?
Yeah, I
So
don't
what
want
would-
to jump. I don't want to jump forward, but and you may go over this, but do you have to keep employees' records for a certain period of time after they leave?
Yep, and it depends on the records. Business records, 10 years, employee files, 3 years. Certain employee documents within there is also 10 years, and we'll go through that in a couple of slides.
Okay.
Did Marion have another question though? I'm sorry, we didn't mean to cut her off.
No, it's okay. I was just saying with the providing it electronically, or can we put it as part of like the new hire kit?
Yeah, absolutely. In that case, I would have a new hire checklist that says it's included where they sign off on it or initial it. that they've received
Got
it just like you with the handbook.
Right. Okay. Thank you.
Yep. Sure. All right. Okay, fun ones. Understanding payroll taxes. Payroll taxes are imposed on employers or employees, or both, to fund Social Security, Medicare, and other government programs, including federal income tax, Social Security tax, Medicare, state income tax. Businesses need to understand and comply with these taxes to avoid penalties and ensure proper funding of government programs. Did I sound sincere enough in my reading of that? All joking aside, payroll taxes are a very easy way for you to mess up if you're not paying attention, but it's also one of the simplest things you can do to protect your business. It's a double-edged sword. As long as you have the right systems and processes in place, you'll be fine. So don't let all the jargon scare you on that. All right, let's talk about the fun stuff. Job descriptions. This is your first introduction to the public. First piece of communication that introduces the company, so it's important to make sure that you keep it uniform, get the right impression. This can help you recruit top talent, and it will also make an impact on future clients, right? So a brief summary, 1 to 2 sentences of a high-level introduction of the company and an overview of the job. The reporting structure, who will they report to? Title, not the name, right? This position will report directly to the CEO, the owner, the president, whatever that is. Classifying correctly. Are they going to be exempt, which means salary? Side note, if they're salary, they need to make sure that the position is qualified to be salary. We'll go through that a little later. Or non-exempt, hourly. And if they're hourly, any hours worked over 40 is qualified for overtime, which is time and a half. And then some states have different requirements when it comes to overtime. And they need to make at least federal minimum wage if you're in Indiana. Any other state, you need to make sure that the state minimum wage is the same as federal. Otherwise, if it's higher, you have to pay the higher rate. Also, this is where you need to make a detailed list of what must anyone do day to day that is critical for the position to be successful. Also the essential functions. Ergonomic requirements. Sitting, standing, walking, lifting. What are they required to do in the work environment? You should put rough estimates of percentage of time doing that in the day-to-day. So 50% sitting, 25% driving, 25% standing, walking. So the individual applying knows the basics of ergonomics that they'll be required. And then you should always have the equal opportunity employer disclaimer. Make sense? Okay. Hiring onboarding packets. All right. This is a list of what needs to be in a new hire packet at a minimum. Don't forget, some states require additional documents, and it's imperative that you check your state law when building your packets. Offer letters. It is not a requirement to have an offer letter. It is a best practice to have an offer letter because it helps to keep the information standardized, and you'll see more importantly how this will interact with background checks on the next slide. But it also gives you a record of this is what I communicated to the applicant on when the job starts, how much they're going to make, all of that information. And here's where they signed accepting all of it. So now that they're saying that's not what they were told, is null and void. Application or resume, you want to always have those in file because you want to be able to defend your decision to hire somebody at any point. W-4 for federal and state taxes, those need to be kept for 7 years. I-9 and IDs for the I-9, are required to be kept for 10 years. Background check if required. Have an emergency contact form. And then paycheck distribution. Direct deposit, live check, pay card, whatever it is, always require a voided check or banknote with the information for direct deposit. And then any state required documents. Questions?
What's the I-9, Pavithri?
I-9 is the immigration document that is done by the Department of Homeland Security. And that document carries a lot of weight. In all its entirety can carry up to a $10,000 fine per document. It's $1,000 per mistake.
Okay.
And not doing one, I do have some more information at the end, but yeah, I mean, it's controlled by the Department of Homeland Security, Immigration and Customs Enforcement, and the Department of Labor. So it carries a lot of weight, and it's important that you know how to do it and how to do it right.
Okay.
So I have a question. All of my staff is 1099s and they meet the requirements, but I do not. Do I need to do an I-9 for them?
No, we're still on W-2s.
So it's only for W-2s. Okay.
Correct.
All right. Thank you.
Sure. Nicole?
Yes. Hey, Pavithri. So
Spencer's in the background telling me who's raising their hand, by the way. That's how I know.
Thank you,
Thank you,
Spencer.
Spencer.
I wouldn't have said that. I would have just kept that cool.
Credit where credit's due.
Absolutely. So the I-9, is that where we share like our social security card and our ID?
Yes.
Okay, that's what I was thinking. Okay, thank you.
All right. Any other questions on this slide? All right. All right. Background checks, recruiting and interviewing, do's and don'ts. Recruiting and interviewing. To have a consistent job description. Please, whatever you do, don't ask them about their medical conditions. You can ask if they can perform the essential functions of the position with or without an accommodation. And if they ask for an accommodation, please engage in the interactive process. And if you don't know what that is or need help with that, let me know. I can help you. Don't ask personal questions. Stick to questions relevant to the job. Don't make it overly complicated. Background checks. Post-offer pre-employment. So what does that mean? Sign up with a proper background company. Some payroll systems do provide a certain limited number with your payroll services. Do not use Google. That is not a proper background check. Do make the offer contingent on them passing the background check. Don't ask them about it during any step of the hiring process. If anything does come up in the background, you need to engage in doing an individualized assessment before offering or declining the offer. Indiana right now does not have any state laws, so it follows the federal EEOC guidelines. Some states do have explicit laws surrounding this. And I always say employment law comes out of somebody doing something crazy somewhere that makes lawmakers go, we need to make sure that we make this a law so everybody follows it, because clearly people aren't smart enough to follow it, because, yeah, I go down those rabbit holes of trying to figure out who did what stupid thing to make a law happen. Like in New York, it says it's illegal to watch a video while you're driving if you're driving for work. And I'm like, okay, who's the idiot, right? So I go looking for that. But this particular one actually came out of Pepsi, who had a policy that simply said, we don't hire felons. Neutral on the face of it, right? It's not a discriminatory statement. It just says, we don't hire felons. Well, what ended up happening was, with the EEOC digging in more into it, they figured out that a disproportionate number of African American males are subject to wrongful incarcerations and felonies, and they are being kept from the workforce because of that one policy, which is why you are required to go through an individualized assessment to determine if the conviction has anything to do with the job and if they pose a threat to the employer, or the employees. Questions? By the way, that one little line ended up costing Pepsi $12.7 million. All right. Why do you need a handbook? You are required to keep a complete and up-to-date employee handbook in some states, but you are required to keep a complete and up-to-date company policies and procedures, so that if there is a government agency charge and they ask, well, how did the employee know they had to do this? You're able to show it. A handbook is honestly one of the most important documents your company needs to have. Only things worse than not having a handbook, though, is not having one that is not updated regularly. You should have your handbooks updated annually. January and July tends to be the times that most legislations pass new laws. So you want to make sure that going into every new year, you're having your handbooks updated, having employees sign off on those. This is also your chance to communicate your policies, procedures, expectations, benefits, all of that. It brings uniformity across the company, explains everything, saves time on your personnel and administration staff, document the rules, helps new employees to set their expectations from the company in terms of work schedule, leave, compensation, benefits, dress code, performance reviews, all of it. Employee handbooks should contain maybe a welcome message from you. That would be nice. At-will relationship. It classifies that the handbook is not an employment contract. Basically saying like, hey, this is a relationship that can be terminated by you or by me for any reason with or without notice. Now, I will say that and say it's at will with just cause. You can't fire somebody because you don't like what they're wearing. Yes, that's happened before. Your equal employment opportunity information should be on there. And then some states do require protection based on other classes. So it's important you include all of the state protections. Indiana actually has a whole list of different laws that you need to include as far as protections are concerned, right? What conduct are unacceptable, compensation and performance, pay periods, pay days, timekeeping, overtime, all of those things that needs to be communicated. Benefits isn't just about health insurance or IRAs or retirements or anything like that. It's also about paid time off, sick leave, disability, jury, voting, bereavement, and then state-specific leaves. Health and safety, right? OSHA laws and regulations that they may be subject to depending on the industry. And then workplace guidelines, off the clock work, off duty conduct laws, meals and rest breaks, accommodations, attendance, personal appearance, all of it.
Yes.
Yes. Go
Oh,
ahead.
sorry.
No,
Sorry.
you're good.
I didn't know
Michelle-
my mic was on.
Oh, sorry. Okay. And then you need to make sure you have an acknowledgement of the receipt, right? They're signing off saying that they got the handbook. It doesn't mean they actually read it, but you're giving them the handbook. If they choose not to read it, you're still holding them accountable to what's in the handbook. So like I said, you want to make sure that you're updating this on a regular basis. And if you're operating in multi-states, I highly recommend you have a national handbook that covers the company policies and all of the federal laws, and then have separate state addendums. So that way, if there is a new state you're adding somewhere in the middle of the year, you're only having to add that state addendum versus having to update your entire handbook all over again for one employee. It's just a easier way to do it for small businesses, so they're not constantly having to spend extra money on updating their handbook throughout the year when they're adding a new state. So that is the end of the W-2 process. Questions, comments? We good? All right, we'll go. Oh, sorry, Jennifer, what's up?
No, nothing. I was just giving you the thank you good, and then I yawned and I'm thinking, I don't want you to think I'm bored, but my goodness, what a lot of information to keep track of. My goodness.
That's why we're recording this.
Yes, we are. Okay. Yes, you are right. But thank you. No, I don't have any questions. Thank you.
Okay. Well, I would like to say let's get to the fun stuff, but let's be honest, the Department of Labor has made sure that this is no longer going to be a fun conversation. So the new rules for the Department of Labor goes into effect on March 11th. So what does that mean? If you currently have 1099 contractors working for you, you need to now look at these 6 factors in determining if they still meet the independent contractor test. A finding of misclassification can result in expensive penalties, such as unpaid overtime and minimum wage, liquidated damages, and attorney fees. The IRS can levy additional penalties for misclassification, including criminal charges. If the IRS suspects an employer intentionally misclassified its employees, employers should take precautions such as consulting a checklist or structured guidelines each time they hire a new worker. Implementing a standardized system will help to clarify the status of all new hires. And you should also conduct routine checks to make sure that the workers who you've hired as independent contractors are not being treated as employees over time due to a shift in the nature of their work. Employers should also recognize that it's not a defense to a misclassification to claim that a worker requested to be treated as an independent contractor. That was a mouthful. Questions? All right, I got about 8 slides of information on the 1099, so we'll go through it, and it's going to be a lot to digest, so we'll definitely interrupt me if you have questions. All right, so any opportunity for profit or loss a worker might have. What does that mean? So it's going to look at, would the employee have had an opportunity for a profit or a loss depending on their skills? Whether they could have meaningfully negotiated a pay for the work provided. They will also consider if the worker can decline jobs or can choose the order and time by which the jobs are performed. And then the DOL will consider if the worker engaged in marketing and is attempting to expand the business. Finally, it will consider if the worker makes hiring decision, purchases material and equipment, and or rent space. Financial stake and nature of any resource a worker has invested in the work. In looking at investments, the DO will consider if any investment by a worker are capital or entrepreneurial in nature. So costs such as purchasing worker tools and necessary equipment, labor costs, costs that the potential employer poses on the worker are evidence of capital or entrepreneurial investments. And then degree of permanence of the work relationship. If the relationship between the potential employer and the worker is indefinite in duration, continuous, or exclusive of work for other employees, the worker is likely an employee. Nature and degree of control. They will definitely look at the employer's control, including reserved controls. Meaning, does the employer have a major degree of influence over how they perform the work and the economic aspects of the working relationship? They'll look to see if the potential employer sets the work schedule, supervises work, or otherwise limits the worker's ability to work for others. Control will not be found, however, when the potential employer demands that the worker abide by regulations imposed by OSHA and any other applicable law. The extent to which the work performed is an integral part of the employer's business. So to figure that out, the DOL will not consider whether the worker is an integral part of the business, but rather whether the function that the worker performs is an integral part of the business. An employee will be found to be an employee and not an independent contractor if the work being performed is critical, necessary, or central to the potential employer's principal business. And then skills and initiatives. The DOL will consider whether the worker uses any specialized skills to perform the work and whether the skills contributed to the business, like initiative. So if the worker obtains skills from training provided by the potential employer, the individual will not be an independent contractor. And then look at any other factors that might indicate whether an individual is economically dependent on the employer for work. So are you their only client? Are you dictating when they work, how they do their job? Are you providing all the necessary equipment to do the job? To truly be considered an independent contractor, you need to be an independent agent running your own business. DOL consequences for misclassifying your 1099 contractors. It can get expensive. So there's about 9 points of penalties. So I'll try to go through them quickly. Wage law violations. The statute of limitation is 2 years for non-willful and 3 years for willful. The DOL has hired a lot more investigators because of this is a huge focus for the agency right now. It can also carry criminal penalties for executives who continue to disregard unpaid employment taxes, I-9 violations. So this is where you as an employer is required to validate that the individual that is working for you is eligible to work in the United States legally. By not having an I-9 in place, you are illegally employing individuals. This is governed by DHS, ICE, and DOL, and will include civil and criminal penalties. Audits target businesses that are not closely controlled, like construction and home health care. Unemployment insurance shortfall. This usually is uncovered when there is a discrepancy between the employer's quarterly wage list and the employee's contribution report that is submitted. Unpaid workers' compensation premiums. Stiff penalties for violating state workers' compensation insurance laws and liability for unpaid workers' comp premiums. Not to mention missing filing requirements. Remember my story from the beginning about the $100,000 fine? Yeah, that was from the state OSHA agency, by the way. Improper exclusion from benefits. This can become a costly lawsuit. Additionally, remember when I said an employee is not required to provide health insurance till you have 50 full-time employees? Yeah, if you're keeping that number down by using 1099, unfortunately, you're going to pay a stiff penalty. Anti-discrimination violations can result in failure to provide required protections to individuals under state and federal anti-discrimination laws. Failure to provide job-protected leaves, expensive lawsuit. Failure to provide the required notice. Again, it's a recipe for an expensive lawsuit because by law, you have to know if you are required to provide stuff like the WARN Act. And if not, then if you're using 1099s improperly and you don't provide it, that's going to cost a lot. Under the IRS guidelines, employee misclassification penalties can be up to $1,000 per misclassified worker and 1 year of prison time per worker. Bottom line, you can't afford to misclassify. Any questions on before yeah,
It
go ahead.
it might be I don't know, this is gonna sound, but if you work with you or work with somebody because I'm thinking this is enough to scare, well, it's enough to scare me, but we don't have any employees at this time, but it's enough to scare you. If you know how, let's say you work with somebody. I'm not asking you to what's the word? I don't want you to think you have to give me an answer that isn't there. But if you're working with somebody who does your HR, do you have some kind of warranty or guarantee or something in the event that, okay, that would be my question. You know what I'm saying?
Yeah, absolutely. So here's the thing is that for me, if you choose to work with my company, there's a few things that I have in place that protects my clients. Okay.
Okay. That's what I guess I'm asking.
Yeah.
Yeah.
So first and foremost, I am a 100% 1099 for your business by current test and the old test, because I am an independent agent who owns my own business. I have multiple clients I provide this service to.
Okay.
Although you may have me long term, I also have a very structured end date of what that looks like. I don't work exclusively with clients who have more than 150 employees. Can I stay on as a consultant on the outside? Absolutely. But I will not be your primary HR person after that point.
Gotcha. Okay.
Also, I carry liability insurance for professional services.
Okay.
If I make a mistake, my clients are covered under my liability insurance. So when you work with me, you get a contract that outlines all of that and a COI, a certificate of insurance that shows that you are a covered entity under my policy.
Okay.
Can I ask a question?
Absolutely.
Yeah. Go for it, Lisa. Yeah.
So I've talked with my HR kind of consultant that I've used for my company already, and but your slides make me kind of want a second opinion. I have a situation, she does work exclusively for me, but not by my demand. She just doesn't have any other clients. She doesn't have time. She doesn't want to take on other clients. She's a stay-at-home mom. She homeschools. She only works a few hours. So she only works about 10 hours a week as it is.
Does
That's
she
all
have
she
her own
wants.
business?
She does not. She has not set it up as her own business. I pay her as a 1099. I do not provide any equipment. She has her own computer. She sets her own schedule. I don't dictate her schedule. I do provide time tracking software for her to use, and I provide her an email to use.
You're in trouble.
Okay, that's okay.
It's a very fine line between the two, Lisa, that it's not worth the risk for you.
Well,
I understand that she wants to use, I understand she wants to work part-time.
right.
And I get all of it, right?
Yeah.
I'm not saying take it away from her, but it is, while the cost on the front end would be a little bit more, the penalties you'd save on the back end if you ever get audited is worth the payroll setup.
Is the only trouble though the fact that she doesn't work for anyone else?
It's the fact that she doesn't work for anybody else, the fact that she is not a true independent agent,
Okay.
and the fact that she is using your internal systems to track her hours and uses your email system.
Okay.
So as an HR consultant, like any of my clients, employees that interact with me, emails to KPSK emails, not the client emails.
Well, but I have several clients that have set up like an admin at their domain, and we use those emails, but we're not an employee of them.
No, but you are a independent agent, meaning you
Right.
are a different business providing a service.
Okay.
That's the difference.
Okay. So, okay.
Like one of my clients has a time off at the client name, and I'm included in that mailbox. So
Right.
I get copied on those.
Okay.
But if somebody's trying to reach me from the company, they email me directly.
Okay. Well, I don't want to keep up other time, but thank you.
No, that's okay. Yeah.
So,
Anybody else? Jennifer, did you have any other questions or you good?
Trying to unmute. No, you're answering a lot. I just was the terminology. I mean, I was an insurance agent, but I didn't deal with, liability like you're talking. I talked, but that's exactly what I'm wondering, I mean, it's kind of like, oh my gosh. But if you're working with somebody like yourself, thank you. That made a lot of sense. Thank you.
I have just a few more slides left before we get to Q&A. Is everybody good on time, or do I need to? We good? Okay. I'd assume somebody would yell if they weren't. All right. So now that we've figured out how to make sure somebody is a independent contractor, let's make sure how you protect yourself when you have a 1099. Hiring a 1099 is simpler. You only need a few but important documents to protect yourself. Just remember, it's a relationship between two companies and not an employer-employee relationship, okay? It is much simpler than employees. The reason there is less paperwork involved is because the relationship is, like I said, it's between two independent entities, right? An independent contractor may be one or more people who are in a separate business from you. So freelancers like artists, planners, web designers, outside companies doing cleaning work, or professional service such as attorneys, consultants like me, anyone you're paying for services and who is not an employee. They're also considered to be self-employed, owning their own business. 4 things that I think are very important for you to protect your business with. a W-9 form with the person's contact information and taxpayer ID number, a resume to verify the person's qualification references. So I always provide my clients with services I offer and also a capability statement that says, here's how I got my experience. Certificate of insurance showing your company as a covered entity. A written contract showing the details of the agreement between you and the independent contractor. Scope of work, including when the job is to be done and deadlines. Amounts and time of payment, when payments are due, what happens if payments are not made. Clearly defined ownership of work, who owns it, the company or the contractor. The most important clause in this contract should be a statement that this person is an independent contractor, not an employee. It's essential that both you and the independent contractor understands the type of relationship and the fact that they are responsible for paying their own income taxes and Social Security Medicare taxes. Restrictive covenants, especially making sure that the scope of work the contract is doing is not something your regular employees do. Protect your proprietary information, a confidentiality agreement. A non-compete agreement. This one is a tricky one in the 1099 world because you can't restrict a 1099 from taking other jobs with your competitors, but you can restrict them from taking your customers, clients, and most importantly, taking your information and starting a new business for themselves that compete with you directly. So Jennifer, pretty much like what Greg was talking about during lunch with the solar business. And then non-solicitation. Your handbook has this provision, should have this provision for your employees to keep them from working for the competitor and taking your employees with them. It needs to also be in your 1099's contract from stealing your customers, right? All these agreements, the key is whether you can take the person to court if they violate the terms of the agreement. The more restrictive the agreement is, the more likely a court will look at it and it has a restraint of trade and throw out the agreement. Excuse me. And being reasonable to terms of time and distance can make it more likely the court will hear your case. All right, one more slide and we'll be done. So common mistakes employers make in the hiring process. Making regular long-term relationships as if they're an employee, right? To have business consultants, IT, accounting, marketing, okay. But if they're doing the same job every day, long-term, you might be crossing into employee status. Dictating the use of equipment or software. By definition, 1099 contractor is an independent employer. Scope of work should cover all the requirements of the job, but not dictate how it should be done. Setting a schedule for contractors. It's okay to let the contractor know the project specifications, including the timeline, but you should not be setting the schedule for the contractor. Making the contractor work in the office, paying wages and expenses incorrectly. Independent contractors can do their work anywhere. And if they come into your office to do the work, should be their choice. So for example, a IT consultant wanting to remote into your system versus come in the office to address or troubleshoot a product. You as a business owner is not required to turn over independent contractor documents to anyone. But if you are ever audited by the IRS or you need to verify the relationship, you will need to produce them, create a file for each of the independent contractors you hire with the documents. Mistakes the employers can make in W-2s, misclassification. If you're going to pay somebody a salary, you need to make sure that the position is exempt from overtime. If somebody works over 40 hours, you need to make sure they get paid overtime. And they're not setting the salary at the right threshold. Right now, an employee needs to make at least $687 a week for the salary threshold. or $7.25 for an hourly employee as the minimum wage. Not filling out required documentations. I can't emphasize this enough. I-9s, I-9s, I-9s. And then failing to provide protections required by law. All right. I can actually see everybody, so I know we're a couple of minutes over. Questions, comments?
I have several questions, so I may need to.
I was going to say, do we need to go off, do we need to turn the recording?
Well, I think I can ask just one more, and then, because I just got told supper's ready, so I need to go anyway. But
Okay.
I get what you were saying about my one employee, but then when you went through the next list, I mean, I have the contract. The contract was reviewed by a lawyer. He said it was good between me and her. It clearly states she's not an employee. The only thing that I see on your list that puts me at risk is that I provide her an email address, which my clients have provided with me as well, and that she uses my time card software, but she doesn't clock in as herself. She clocks into a project. Does that make sense? So like,
yeah,
she'll go,
you might want to have your attorney take a look at that again against the new regulations.
okay, because it's like I'm going to use Jennifer since she's one of my employees, even though the person doesn't actually work for Jennifer's account. But like, she'll go to my software and clock in that she's clocking into TTR, and she does so many hours, and then she clocks out of TTR and clocks into ABC company. So it's not she clocks in for the day and clocks out. It's she's recording time to individual projects.
That's
So I don't know if that matters.
Yeah, actually it does. That makes a big
Okay.
difference.
Okay.
Yeah.
Okay.
So when you said you're her only client,
Yeah.
you are outsourcing her to your clients.
Yes.
That's different.
Okay. Okay.
Is that a good thing?
Is that, yeah, that's the next thing.
I would
Okay.
still have your attorney check that contract to make sure it is in line with the new.
I will do that. That's
Yeah.
a good advice. Thank you. Okay. Supper's ready. Great information. I want to see the replay because I'm sure I missed things, but I'm glad I was here. So
Good,
thank you for your time.
Good. And it will be, we'll send it out and it'll be on our website and all that kind of stuff, but I'll send it out to everybody that's attended today. It was great information, Pavithri. I mean, obviously, bye, Lisa, but really, truly, I'm sitting here biting my fingernails thinking, oh my gosh, luckily, yeah, amazing. Anybody, oh, thank you. I don't mean to cut anybody off because we are over 8, but does anybody have anything else?
It really is a lot of information. I understand, especially from my audit and compliance side, how important it is to get it right. So I certainly want to look at the recording again and make sure that, that I have a good understanding, and I may likely have questions for Pavithri at a later date, because there are aspects that it does seem like it's a fine line, and there are a lot of unique circumstances that can fall, here or there. So, yeah, thank you so much for sharing all this with us tonight.
Absolutely.
Do you, Pavithri, yes, let me do that.